Hello, this is Eric Sauver with the Law Office of Eric M. Sauver. For those of you that are still on the page, I want to thank you for your patience. We've been experiencing some technical difficulties and glitches in presenting this employment law, business law presentation workshop for all of you folks who are no doubt at home as I am. In any event, I'm here today on this first time live streamed workshop seminar. My name is Eric Sauver, and my law practice is called the Law Office of Eric M. Sauver, and I practice employment law, labor law, and business law for small to mid-sized companies, business owners, employers, etc. And I first want to thank the Yard co-working space. Thank you for helping to host this video live with your members, many of whom I know personally, having an office at the Yard, which I know is a great co-working space. I also want to thank Liz Wright for all the last 35 minutes of tech support. So thank you for that. So in any event, and again, for those of you that are watching, thank you for your patience. We had a little technical difficulty there. So this workshop will be given live streaming, and the topic of the workshop is COVID-19, the coronavirus crisis, and how it impacts businesses, what you as a business owner need to know about this crisis and how different employment laws are being passed and different labor laws that you have to follow. Just as a kind of intro, it's no surprise in the past 2 weeks, I think nearly all of us have seen our lives just turned upside down by the devastating impact of this coronavirus, of this COVID-19 pandemic. There are a lot of unknowns about the path of this virus. We don't know, for example, how long some of these drastic changes that have been taking effect will be in effect for. There's a very lingering fear of serious illness or death or an economic devastation. People are unsure what's going to happen to their business, and they're wondering. And understandably, many people are experiencing some fear and anxiety, much like the anxiety I was feeling for the last half an hour trying to get this thing up and running. But in any event, when you're in that anxious state, it's sometimes very difficult to take in all the information coming at you. And so what I'd like to do today is focus on three main points of relief and also three main points of employment law legislation that applies to you as a small business owner, whether you have one employee or 500 employees, whether you have a single solopreneur or whether you have several companies. And in doing so, I'd like to narrow the focus. I think in this age now, we're kind of all being hit with a ton of information all at once. So I'll talk about the recent federal legislation that just passed. That's the Coronavirus Emergency Family Medical Leave Expansion Act, mainly the Families First Coronavirus Response Act, and how that applies to employers. I'm also going to speak about some New York State legislation that you as a business owner in New York should be aware of, and that's both the recent executive order, the New York State on Pause executive order, and some changes to New York State's unemployment legislation and some quarantine leave. So mainly we'll be covering basic topics of changes to paid family leave, what you need to provide, changes in terms of sick leave, what you as an employer need to know, and then some questions on unemployment insurance. And lastly, we'll talk about some things I know everyone's been thinking about, which are some stimulus packages, what is in the works right now, what kind of tax credits can you as a business owner apply for, and what must you do to be eligible for those tax credits, and how do you relate to unemployment insurance for your workers and all this. So I hope I'm still live right now. I think I am. Liz, can you give me a thumbs up if I'm still live? I think I am, so I'm going to keep on talking here. Okay, so in any event, the first thing I'd like to cover today, and by the way, I'll be taking questions during this workshop. I think it's best to go in segments, then go from there. Okay, so I see I'm still live. Great. Okay, so the Families First Coronavirus Response Act is a very large, comprehensive stimulus package, and there are many provisions. It's extremely voluminous. My focus today will keep you narrowly focused on two main provisions that you need to know about, and a third provision that has not yet passed. And the first provision we're going to talk about today, and this is again from your perspective as an employer, but many of you watching might also be an employee somewhere. You might have a startup company and you're working somewhere as a B job, so this can impact you as well. So this is the issue of the Emergency Family and Medical Leave Expansion Act. So many of you might be aware of, have heard of the FMLA, the Family Medical Leave Act, and that was passed in 1993, and that basically applies broadly to companies that have at least 50 or more employees in a 75-mile radius from a location. So it's a little bigger companies, 50 or more employees. It provides 12 weeks of unpaid leave. This is the Family Medical Leave Act as it has been written for the last 27 years and still stands today. And it allows workers to take this unpaid leave, protected leave, under certain health conditions or to care for a close family member or spouse or child who is sick or injured, care for their own personal health issues. So what this new legislation is doing, meaning this new Families First coronavirus impact law is doing, is they're taking the FMLA and they're expanding it when it relates to COVID-19. So let's talk about what that looks like. So the first change we see is that this new act, this new federal law, covers a larger array of employers. It covers employers that have up to 500 or fewer employees in their ranks. So this again means that if you have 500 or fewer employees, which could be, for example, you are a business of maybe 499 people or a business of 10 people. A business of 10 normally would not be subject to the FMLA, but under these new expansions, under this current legislation, you are in fact eligible or covered by this legislation. So what this requires right now is that if you have 50 or fewer employees, you being the employer, the business owner, you have to provide up to 12 weeks, and that's of leave. 10 of those weeks are paid leave, which is different, again, than the Family Medical Leave Act. And 2 of those weeks, the first 2 weeks, are unpaid leave. Now, with the unpaid leave for the first 2 weeks, I'll get to that in a moment. Let me talk about, again, who the eligible employees are. This law applies to employers, so it applies to basically employers, meaning again, a company, a public or private sector. It exempts employers in the healthcare industry, emergency response, so private organizations that provide, for example, EMT type services, public hospitals, etc. But all other public and private employers are covered. And then the eligible employees would be any employees of your company. Think about your employees who are full-time or part-time, it's important to note, who work for your company, work for the employer for at least the last 30 days prior to taking their leave. So it used to be the employee, or I should say it still is for FMLA leave, an employee has to have worked 1,250 hours for your company. Now, not true anymore. It could just be 30 days. So an employee who worked 30 days at your company can be eligible to take this leave. Now, the question then comes up, I'm sure, when can they take this leave? Under what circumstances can they take this leave? And it's a very narrow type of leave they can take. And here's where the law states right now. The leave provided, like I mentioned, the first 10 days are unpaid. Quite significantly, your employees do have a federally protected right. They have an option. They can choose to use any of their current PTO, vacation time, any sick leave they have maybe banked up from your company, and they can apply it in those 10 days. They can opt to do that, so that the first 10 days of the leave, which are unpaid by the statute, are paid in some way. Now, you as an employer cannot request that your employees take their sick leave in those 10 days. And importantly, you can't use whatever paid leave, whatever vacation days, you cannot ask an employee to use that time in lieu of this paid leave. So think of it as the federal statute, right? It supersedes whatever your current company's employment or vacation PTO might be. So you have this leave where people can take these 2 weeks unpaid. Again, employee can decide to supplement that with their vacation or paid time off, and if they have it accrued. And then the remaining 10 weeks of the leave are paid as follows. We have full-time employees, and those employees are receiving 2/3 of the regular rate of their pay for the number of hours the employee would otherwise be normally scheduled. So just to clarify also that in order to qualify for this leave, as it relates to COVID-19, the main and frankly only criteria right now is that the employee is unable to work or unable to telework, can't work from home, can't work right now, because they're taking off to care for that employee's child, right? Defined as somebody under the age of 18. So that's an employee who is under 18 years old, who is an employee of your company, and they're home, and either they're taking care of their child whose school or whose child care provider or service is closed, which in this case I think would apply to anybody watching now who has children. I know that my wife and I, our son's child daycare is closed right now. So if an employee is seeking this leave, if they come to you and say, hey, my child's school is closed, my child's daycare is closed, and it's closed due to a public health emergency of COVID-19, right? It's a COVID-19 related closure. So this can't be a school that closed down because the school's funding ran out. It has to be closed based on the coronavirus and all the different public health ordinances around that. So then what is that employee entitled to, right? They come to you, they can show evidence that their child care, or it could be their nanny or their au pair, maybe can't work for them anymore, and they're home with their child. And remember, they're not working, and they're not telecommuting or teleworking. So then the next question is, what are they entitled to? And that's where we get to the pay that they have here. So those employees can take, again, those 2 weeks of unpaid time, and then 10 weeks paid at 2/3 of the employee's rate. Now, the pay for each day is capped at $200 a day. So you might be doing the math in your head and thinking, geez, I've got some high paid managerial employees who are making a fortune, and if I have to pay them 2/3 of their salary, that could be $2,000 a week. And just to reassure you that the cap is $200 per day, and it's usually a 5-day week, so you've got about a $10,000 over the 10 weeks total per employee that they can claim under this emergency expansion of the Family Medical Leave Act. So one common question I've gotten, what about my part-time employees? Are they eligible? Answer is yes. And the next question is, okay, I have a part-time employee, he or she works 20 hours a week. Their child's in daycare closed, they cannot work or telecommute. Maybe their child has special needs, maybe they have full-time obligations to attend to. How much do they get paid? 2/3 of what? And so the answer to that question is, for employees who have worked for the last 6 months, you take the average of the hours the employee has reasonably worked or expected to work at the time of hiring, and then you calculate either 2/3 of their hourly rate, if they're an hourly employee. If they're a part-time salaried employee, that's pretty easy. Just take 2/3 of their salary, of their weekly salary. This law also provides certain protections around job reinstatement. So it's important for you to know as an employer, especially now when you might be restructuring your company, you might be deciding we have to get some layoffs, whom are we going to cut? Whom are we going to keep? That if you have an employee who's out on this Emergency Family Medical Leave Act expansion and they're taking this leave, employers with 25 or more employees, you have a legal obligation to return your employee to the same or equivalent position. So if you're going to cut employees, that would not be the person to cut, ideally. Employers with less than 25 employees do not have to return the employee to their previous position if they can show that doing so would create undue hardship or economic duress during this time. So if you're a 10-person company or firm, or you're a store or a tech startup maybe, and you only have 10 employees and 2 are out on this emergency paid family leave, when they come back, if you can show that you cannot put them back in their place, there's just not enough money, you are protected. You don't have to worry about a retaliation lawsuit. So I would also note that employers of 50 employees or less can try to be exempted from this act by claiming undue hardship, by writing to the Secretary of Labor, contacting the New York State Department of Labor as well. Although this is a federal bill, but you can go through both channels and state your case. I would caution, though, that it would be a very arduous audit of your financials, your books and records, and so if those are not 100% up to date or in place, you might want to rethink, going for that exemption from this. Rather, you might want to instead either A, borrow the money, possibly if possible, to fund these paid leaves, or B, talk to your employer insurance if you have employment law insurance. See if your your insurance is covering this. Or C, wait for the tax credits, which I'll get to in a moment, because there are tax credits that are allowed for small businesses who are required to implement this emergency paid family medical leave. Before I get to the next component of this leave, which is emergency paid sick leave, are there any questions from anybody in the audience? My brain is just, after 35 minutes of technical problems and glitches, still kind of refocusing. So if I missed anything, please let me know. If anything was a little unclear for you, you can type a comment in the comment section here, and I'll see it. You can also shoot me an email as well at ems@ericsarver.com. So, emergency paid sick leave. What is that about? So part of this stimulus package, part of this Families First, this coronavirus Families First Relief Act, includes emergency paid sick leave. Basically, that employers must provide paid sick leave to eligible employees for a set period of time based on that employee's COVID-19 related illness or suspected illness. Keep in mind that these laws don't preempt or overturn any existing laws that might exist in your state or federal laws, or in New York City, for example, around other reasons for sick leave, like if a person is sick with, say, a stomach virus or a case of the flu. But these emergency provisions are meant to address people who either have COVID-19, people who suspect they might have COVID-19, the coronavirus, or people who think they're at high risk of being exposed to coronavirus, COVID-19. So, which employers are covered? If you're watching and you're an employer of less than 500 employees in the private and public sector, guess what? You are covered by this law. Employees covered would be those who are not required to have any days of employment before. So the emergency family medical leave that I spoke about a moment ago, if you remember, has a employee had to have been working for you for 30 days. And under this law, the employee can be working for you for 3 days, for 300 days, doesn't matter. If they're your employee and they're taking a COVID-19 related paid leave, which I'll discuss in a moment, then you do have to offer them this paid sick leave. I'm going to get into how much paid sick leave, how many hours of paid sick leave, and what are the eligible conditions that the employee must present notice of and documentation of as well. So, in order for an employee to qualify for this type of leave, pardon me, the employee must be subject to a government quarantine or isolation order related to COVID-19, not the mumps or measles, not tuberculosis, but if they're subject to a government order, maybe they flew to a high-risk country, maybe they tested positive, maybe they were in a gathering of people who all tested positive for COVID-19. If your employee is, again, part of a quarantine or isolation order, then they can apply for this emergency federal paid sick leave, along with, by the way, New York State quarantine leave, which I'll get to a little bit later on. If your employee is advised by a healthcare provider, advised by their doctor to stay home and self-quarantine due to COVID-19 concerns, and that one I think we need to pay attention to, because I think that more employers are going to have employees calling them and saying, hey, my wife tested positive for coronavirus, I feel fine, but my doctor said to stay home. Or, hey, I had a fever and a slight cough, I called my doctor, there's not enough testing, I'm only, let's say, 35 years old, your employee might be. Doctor said to me, this actually happened to a client of mine, doctor said, you're young, you're healthy, no pre-existing conditions, we're not going to test you, but we're going to advise you to self-quarantine because you might have COVID-19. So an employee of yours that either order quarantine or isolation, a healthcare provider tells them that they should self-quarantine, or they tell you they're experiencing COVID-19 symptoms and seeking medical diagnosis. And that's whether they get a negative or positive test or not. They can take this emergency paid sick leave. Now, for those three conditions I just mentioned, right, think of it as it affects the employee. It's the employee who's being quarantined. It's the employee who is advised to stay at home or isolate by their doctor. It's the employee themselves who is experiencing illness or symptoms. They then get their full pay for up to 80 hours. So figure 2 weeks, 40 hours per week. And if that your employee, let's say, seeks this emergency paid sick leave, this is a federal bill, remember, it passed. It passed Congress, President Trump signed into law effective April 2nd. If your employee is home because they're caring for their wife who was asked to locally quarantine, or their wife maybe or their husband received an order of isolation, or the domestic partner received this order. If they're caring for the employee's child, maybe their child is home from school and exhibiting COVID-19 symptoms. If their child is home because of their school being closed due to the COVID-19 emergency. Or if if their relative or their brother or mother, if they're taking care of someone and they're seeking the sick leave on those grounds, then the employee is then entitled to get up to 2/3 of their pay for 80 hours. So, and then there's of course a cap on this sick leave also. Again, for those of you that have high salaried employees, keep in mind that the cap on sick leave is $511 per day. I don't expect you to remember all these numbers, by the way, but they're there in case you need a ballpark. So figure roughly $500 per day, $5,110 per employee, so roughly $5,000 and change per employee maximum. And if the employee is taking care of someone who's under an order of quarantine, caring for someone who has COVID-19, or caring for someone experiences COVID-19 symptoms, those employees get $200 per day capped up to $2,000 total care for others. Now, a lot of employers have written to me and asked me, or they called me up and asked, will we be repaid for providing these benefits? Sometimes if you have 4 or 5 employees out, this is an epidemic, people tend to catch this, it's contagious. So if you're paying $8,000 and you're losing money, what do you do? And again, the answer to that question is, I'm sorry, I'm seeing some questions on my screen here. I'll get to those in a moment. Thank you. The answer to these questions are that this is a federal law, by the way, so it applies more universally, that employers will be repaid in the form of certain tax dollar credits. So the federal government says they'll refund you in tax credits an amount equal to 100% of what you've paid out for your employees' either emergency family medical leave benefits, those 10 weeks of paid leave and the 2 weeks of unpaid leave, or the 2 weeks of paid sick leave, or both. So you will get that money back, and you're paid per calendar quarter. Now, that might be a hard pill to swallow, because then what about your cash flow? What about your revenue? That might be a challenge that you face. And that will bring me to a part we'll discuss later. And by the way, since we started late, I'm happy to extend this webinar. We were originally going to go from 2:30 to 3:45. I believe we started around 3:10 due to some technical issues. So I'm happy to go until 4:30. If people, have that 4:30 time, please, I'm happy to answer your questions. So you can get this money back. You should not be ignoring these rules, because there are penalties for not complying, right? These are federal government rules. These are enforced by the government. And so if you don't give an employee their paid sick leave, again, given that the employee is eligible, as I mentioned above, and they've applied and they've demonstrated that they need this paid sick leave or emergency family medical leave, not providing that can subject you to minimum wage violations. The government, Department of Labor, can give you fines, penalties. There might be a private cause of action, because the government sees this money as statutorily, basically legally protected, to use less legal mumbo jumbo, legally protected wages. So if you're not paying it, you're not paying employees minimum wage, and that could be very costly. manner. It's yet to be seen if that can result in a private cause of action from an employee against your company, and I believe it would, but I don't think you want to take that chance. So keep in mind, important to know this. The good news is, for those of you who've on this call, you now know some of your obligations for federal paid emergency paid family medical leave and emergency sick leave, and you know that you shouldn't play around with that in terms of not providing it. Okay, so somebody asked me where I'm from. I'm right now I'm in New Jersey, my home in New Jersey. I have my office at the Yard co-working space, which is generously enough broadcasting this seminar to all the Yard members. By the way, I forgot to say hello to some of my colleagues from the Yard in Herald Square. I certainly miss all of you. Look forward to seeing you in person when I return, including some of my clients from the Yard. So, but in any event, there are also a lot of you are in New York State. And so the question is, has New York State created any paid sick leave or legislation that you need to know about? That includes any paid sick leave on top of or in addition to what I just discussed. And as you may have guessed, it is New York, and the answer is yes. New York and California are the two states that have the most generous laws regarding paid sick leave, family leave, benefits for employees. So, New York State requires employers to provide certain paid and unpaid leave, certain job protection, and certain expanded New York State paid family leave, and certain short-term disability benefits. But it's a very narrowly defined New York State paid sick leave. And this is a quarantine-related sick leave. This is a sick leave that applies to employees who are under a quarantine or isolation order due to COVID-19. They have it, and they might have it, and for whatever reason, either their doctor or a local, federal, state, or city government agency or the health department has ordered them to quarantine, or their doctor ordered them to quarantine. In that case, in this narrow eligibility for this COVID-19 quarantine protection, the employee is entitled to this quarantine pay. And again, this is also applies, it's important to note, if there's a school closure relating to the quarantine order, and if the person's quarantining because they're personally sick. So you may have an employee under quarantine order. You know that you owe them this paid sick leave. You know they can take the paid family medical leave, as we discussed. What does New York State say? Well, New York State says that if you have 10 or few employees, and that's measuring back from January 1, 2020, you must provide unpaid job-protected sick time, up to 5 days. 5 days unpaid. And if your net income for your company is over $1 million, then you have to make it paid leave. So 10 or fewer employees, net revenues under $1 million, your employees, again, this is only if they're quarantined and they want this New York State quarantine pay, would be entitled to this quarantine pay, or rather 5 days of unpaid quarantine time. If you're an employer with 11 to 99 employees, I'm going to go through this a little more quickly so we don't get too bogged down in the weeds, all different numbers. But think about your own company, how many employees you have. So 11 to 99 employees must provide 5 days of paid sick leave. And if you're an employer with 100 or more, up to 14 days of paid sick leave, that's what you must provide for this quarantine order. And public employers out there, if there are any watching, have to provide at least 14 paid days of this New York State quarantine sick leave. Now, again, this applies to employers in New York State and employers who work in New York State and employees who work in New York State. So if your employee is working in another state like Pennsylvania, Connecticut, New Jersey, but you're an employer in New York State, there's a question whether that applies or not. And I would consult the New York State Department of Labor on that question. It's sort of an up in the air. It's a gray area. A lot of my clients tell me that they have workers in New Jersey and Pennsylvania and what laws apply. And very often the test is, where is the worker working from? Are they working from New York? They're working from New Jersey, Pennsylvania. But anyway, it's just important to keep that in mind. So now this leave, again, is in addition to the federal leave I mentioned, and this quarantine leave is also in addition to any accrued paid sick leave that you as an employer already provided. So if you have an employee in New York State and that employee is under a quarantine order and they've taken their emergency federal and family medical leave expansion act pay, or they're taking their emergency sick leave and they're seeking this quarantine pay, you cannot go back to them and say, oh, well, you have 14 days of vacation time, so just use that. In fact, they can take that vacation time or PTO on top of this leave. They can stack the two if the quarantine order exceeds the number of days you're supposed to pay them for. So, quick example, you have 9 employees, let's say, and you're only required, perhaps different example, you have 14 employees required to give 5 days of paid leave. They're quarantined for 12 days, so they can take the 5 days of quarantine leave, plus whatever PTO, or if there's New York City paid sick leave would apply, they can stack the benefits. And New York State also allows these people, these employees, I should say, under this Leave Act, to also seek to use portions of New York State paid family leave or short-term disability leave. I realize this sounds a bit, it's a lot to take in, but just keep in mind again that if you have an employee on quarantine and they come back to you and they say, I was told I could take this much leave, they're not making this up. So keeping that in mind. There's also this New York State on pause executive order. So any one of you who lives in New York City who perhaps has been out for a walk lately, maybe down 6th Avenue, and it feels like the apocalypse, like where is everybody? And that's because all non-essential businesses by way of an executive order signed as of March 22nd, 2020, Governor Cuomo signed into law this 10-part New York State on pause executive order. Some parts not too relevant to our discussion today. I'm here to talk to you about employment law and labor law and how that relates to this COVID-19 crisis and what you as an employer need to know. So essential employers, by the way, those are the ones who are often exempt from a lot of these paid family leave, and these are the ones that are allowed to be open. I'll get into those in a moment. But if your business is a non-essential business, and I'm going to differentiate the two for you, then you are under executive order to close your business. You cannot have employees working on site. You cannot be selling goods to customers or provide. You can actually be providing takeout food or delivery because restaurants are part of the essential infrastructure and essential businesses. I'll get to that in a moment. But if you are a marketing company or a digital website design company or an architect, not to say that your work is not important, it's just not deemed essential. So in that regard, a clothing store is not allowed to stay open, and therefore their workers may be home. And that brings us to some other law issues around unemployment insurance, which I'll get to in a moment. So just to backtrack, New York State on pause executive order. Let me just read some comments here. Sorry, someone asked me to repeat for business under 10 employees, how many days, I think you mean of quarantine pay. Is that correct? Is this Marie from Integrity Wines? Just to backtrack, if you have 0 to 10 employees and one of your employees is under quarantine order, New York State legislation says you must provide 5 days of unpaid sick leave, unpaid quarantine leave, unless your net income as a company is more than $1 million. So 10 employees or less, 5 days either unpaid or paid sick leave, depending on how much your income as a company is. So I hope that answered your question. Okay, so let's talk about what is an essential business. A lot of you might be wondering, can I stay open? Do I have to close my doors? What does this mean for me? And also, if I am an essential business, are there limits on what I can and can't do? And again, many of you may have seen that there are limitations, especially in New York State, on what you as a restaurant or a coffee shop or an essential business can do. Okay, so essential businesses include essential healthcare operations, right? That's hospitals, research and laboratory services, including, by the way, privately owned research and laboratory services. So if you run like a private laboratory that gives blood tests or testing devices, you can be covered. Emergency veterinarian or livestock services. I'm not sure how many livestock professionals we have in New York, but maybe we do. It's a pretty big state. Anyone practicing elder care, which is a very popular industry right now. Medical wholesale distribution, home health care workers, right? Doctors and emergency dentists. nursing homes, residential healthcare. I've had so many calls lately from people who are in the healthcare industry, and they have nursing homes, and employees don't want to come to work, and then, can they have the right to take off? Does the employer have the right to terminate them? But those are essential businesses, along with, I can breeze through some of these kind of quickly because I don't think many people watching own an airline or an airport or a public water utility company. But if you are, or if someone you know perhaps may run one of those companies, then they're essential. Along with agriculture, companies that sell pharmaceuticals. That's important in case you're a pharmaceutical company, to know that you might be considered essential manufacturing. Essential retail, right? Have you noticed your grocery stores are open? They may have some limited hours. They may have a number of people that they can and can't let into the store. But grocery stores, farmers markets, gas stations, restaurants and bars. For those of you that are restaurants and bars, you are deemed essential retail, so you can be open. But in New York State, you're only allowed to remain open for takeout or delivery. So I've actually passed restaurants in New Jersey where the ordinances are more, the state hasn't gone full-fledged yet in that regard, the way New York State has, and it goes city by city. I've seen gradually, though, the trend is that restaurants have gone from a few people inside to we can't allow anybody inside. You can take out or deliver. But New York State, for sure. If you own a restaurant, if you own a bar, you can do takeout or delivery service. If you're a bar, by the way, there are some alcohol delivery services. I couldn't speak to whether that's cheaper or not than ordering from other online delivery services, but I can say that if you are in that delivery service, be mindful of any regulations in your industry around the distribution or sale of alcohol, right? In terms of, certain regulations may still apply. So just to keep that in mind. So there are a lot of other laundromat, childcare services, auto repair. If you didn't know, if you run a mechanic shop, you are an essential business. The news media, banks. I will skip around because there's a lot in here, but accounting and payroll I think are important to note because I have a lot of accounting and payroll colleagues and clients who are now open, as well as services related to financial markets. And construction, by the way, skilled trades. So if you get a leak in your house and need to call a plumber or an electrician, they can be considered an essential business, and they can be up and running. They may have to adhere to some rules around social distancing and have some other health ordinances to follow. If you're in those trades, make sure you contact your local human health services agency. You might want to call your payroll company. They might have some information for you as well. I'll skip over defense and other, but just keep in mind that vendors that supply childcare programs and services. So interesting enough, actually, quite fascinating, houses of worship are not ordered closed, churches, temples, mosques, but strongly recommended that they do not have people congregate. So let's talk about the non-essential business owner. Many have written to me before this workshop and asked me, they said, here's my situation. I'm not essential business. I provide important services. I do website design. I create apps that build apps. I'm a marketing strategist, but right now my business is closed due to this New York State on pause law. Can my employees file for unemployment insurance? And the answer is yes, with an asterisk, because there's a lot of changes right now in the unemployment insurance